Good afternoon to you. Thank you for waiting. I hope that we have re-established our connection to you in Pretoria. First of all, the allegation is that speedy VAT payments were made to the Guptas through a third party. Is that your understanding of the situation, firstly, and what is your response to that?
Good afternoon, Jeremy. Thank you for hosting me. It certainly was not a speedy VAT repayment. There was an anomalous and a very difficult situation that the taxpayer in this matter had its bank accounts closed. And after a considerable period of time of queries, they escalated their complaint, that's the taxpayer, to the Commissioner, who then referred it to the legal division to examine how the refund could be made. And I want to place it on record that the refund was in law due and payable. After an exhaustive and detailed audit process, the money was due to the Oak Bay Group, the taxpayer in this case, but the difficulty they faced and what we faced was to comply with the law in respect of the actual payment to which bank account. Now, the VAT Act makes specific provision that VAT refunds must be paid to the vendor's actual bank account to prevent fraud. You can understand, I can pay your tax, but any refunds must be paid directly to you, Jeremy. And in this case, there is a provision in the VAT Act, which was the subject of considerable legal interpretation within our division after the referral by the Commissioner for us to interpret the matter on how to deal with the matter. And there was a differing point of view. I took the view that this was an unprecedented and very difficult situation. And as you know, hard cases make bad law, as we say. But we faced the situation that it was not SARS money. The VAT was due and payable. It had been held by us for a considerable period of time, and we were paying interest on it. And so, to the best of my knowledge, there was no speedy a refund or an intervention by the Commissioner. It was dealt with entirely within the legal division.
Who made the final decision, Mr. Smith, then to pay the money over to this company?
Jeremy, the Chief Officer Legal Counsel, Ms. Moyane, to whom I report, made the final call on the actual interpretation of the law. In other words, could we make the refund to a third-party nominated bank account, from whom, I might add, we were receiving tax payments due to the closure of the Oak Bay bank accounts. And she used Section 72 of the VAT Act, interpreted it to deal with a very anomalous and difficult situation to make the refund. So the ultimate decision lay with legal, and legal recommended to the particular tax division that deals with refunds to enable the lawful release of the funds to the taxpayer.
Given the controversial nature, Mr. Smith, of the Gupta family, are you absolutely convinced that every single avenue was explored in order to reach what you have just conceded was a difficult decision for SARS to make, or should some degree of circumspection perhaps have been exercised, given that you would have foreseen surely some sort of controversy once this became public?
Yes, Jeremy, it's a difficult question to answer, but you know, we thoroughly interrogated the legal options. There had in fact been a previous legal opinion on what does one do in circumstances of this, such as this. And so the actual audit process determining whether the refund was due was in place. So it was simply a technical legal interpretive issue as to how the refund must be made, and whether it could be made to a third party, or whether we even explored whether a court order should be obtained. But we had to pay and ensure that there was no fraud, and that the funds were actually received by the actual taxpayer. And so there was an exhaustive internal governance process, and critical legal views were considered on which differed from one another, as we do in law. And we are of the view that it did receive the attention it deserved.
My argument to you is that it might have been a little more, it would have been perhaps in SARS's interest to be a little bit more circumspect and perhaps err on the side of caution here. But you chose to pay the money, as you've said, because it was money that was owing to this family. Was that third party to whom the money was paid thoroughly vetted and interrogated? In other words, were the bona fides of that account, were they satisfactory to SARS?
Well, I can't really answer that in detail. The nominated third-party bank account, which you referred to, SARS cannot go and examine integrity, etc., in respect of every bank account to whom we pay these monies. We received indemnities from the taxpayer and all the taxpayer entities to give SARS the assurance that we were in fact paying to the correct bank account, indemnifying us because we're dealing with public funds. And so in that respect, we were secured by indemnities from the whole group of the Oak Bay companies. The third-party nominated bank account was apparently the commercial entity that was running their businesses. And so I can't really tell you the detail because it's outside my ambit, what integrity concerns there were with regard to this third party. But we accepted on good faith on the information and the indemnities received that we were doing the right thing.
Can you put it unequivocally on the record for me this afternoon, Mr. Smith, that Commissioner Moyane exercised no influence or any persuasive mechanism against Refilwe Mokwena, the Chief Legal Officer, to make sure that these payments were effected?
To the best of my knowledge, I was unaware of any influence from the Commissioner to Ms. Mokwena. I just dealt directly with Ms. Mokwena. As I mentioned, my view differed from her in an interpretive legal context, and I was unaware of any influence or exertion of power. Refilwe is accountable for the whole legal division and accountable to the Commissioner, and there was nothing in my view or in my knowledge of undue influence here.
Would it have been within your ambit, Mr. Smith, to ask Ms. Mokwena whether she had been adversely influenced by Commissioner Moyane at all, or did that not cross your mind?
No, that didn't cross my mind. I didn't question the bona fides of my... we have a robust legal discussions on matters, and it was particularly robust in this case. And I did not for a minute think that her professional integrity as a legal professional was in question and being influenced by any outside party, including the Commissioner.
You've challenged me on my use of the word speedy. I want to pick up on that if we can. How long did this entire process take in comparison to other VAT payments that are due from SARS to other people who have often complained that it takes too long?
Jeremy, unfortunately, I cannot give you the particular details on the length of period in comparison to other VAT refunds. I'm sure that you're aware that there are certain frustrations regarding VAT refunds, and the reason for that is because we have to thoroughly interrogate fraudulent tax refund schemes, and as you know, there's a prevailing fraud in the VAT space. I unfortunately, in my legal division where I sit, was unaware of the exact period of time. I know that there were queries from 2016, so by the time the refund was made, I believe it was in May, June of last year, several months had passed. I cannot give you the exact details in comparison to refunds for other entities of a similar nature.
And just finally, you would be satisfied that this particular decision would pass any investigative process should it come to that? In other words, you'll stand by your decision.
Thank you, Jeremy. You're really putting me on a spot here. But on the facts before me, I think there's sufficient evidence that the matter was sufficiently interrogated. A discretion was exercised in terms of Section 72 of the VAT Act and can be fully explained as to why it was. You see, Jeremy, the situation here was that we'd never faced a situation like this before. And you're driven by the requirement that VAT refunds must be made because they do not belong to us. And if they are in law due and payable, they must be made and securely made to the vendor who's entitled to the refund. So from the facts that I have before me, I am confident that it will survive any scrutiny from an investigative point of view. But of course, one is not, there are always facts which you do not have. But on the facts that we have, we're happy that we did it correctly.
Eric Smith from the South African Revenue Service in Pretoria, thank you.